Police in Central Florida arrested a woman they say helped her boyfriend attack his ex, and he's still on the run. We're taking a closer look at this strange case and the hunt for a man with a very serious past with criminal defense lawyer Michael Gottlieb. Welcome to Sidebar, presented by Law&Crime. I'm Gillespie. Authorities in Lake County, Florida say 23-year-old Katie Kujawski committed battery when she went with her boyfriend to beat up the mother of his children in a parking lot. Leesburg police say the victim reported the assault on August 1st. She said she'd been arguing with her ex, who's Dinkins. This was over the phone while she was at work. She says he went to the babysitter and picked up the kids, and when she got home from work, the victim had a friend take the children up to her apartment. Now, according to the affidavit of probable cause, the victim said once the children were gone, Nijay's girlfriend, Katie L. Kujawski, stepped out of a car and started cursing her out. Katie then struck the victim with a closed fist, knocking her down to the ground, and continued to hit her while she was on the ground. The victim said she struck Katie back, attempting to defend herself while yelling at Nijay to get her off of her. Nijay was able to separate Katie from the victim, telling Katie to get back in her vehicle and leave the scene. Once Katie left the scene, he walked approximately 40 yards down the parking lot with the victim, then began striking her with a closed fist. This caused her to fall to the ground once again. The victim advised she struck Nijay back in an attempt to defend herself and was eventually able to get away from Nijay. The victim stated once they were separated, Nijay called Katie back to the scene where he entered her vehicle and left the scene with her. Leesburg police took more than a dozen photos of the victim's injuries. An arrest report detailed the victim had bruising and swelling above her right eye to her right ankle, both arms, her nose, and both knees. Katie Kujawski was arrested and charged with simple battery for allegedly striking the victim. She's since been released on bond. But there's an arrest warrant out for Dinkins, but he has not been caught yet. He's also charged with simple battery, but has enhancements for added domestic violence, as well as having prior domestic violence convictions. Dinkins has 2 prior battery convictions from July 2021 and June 2023, and he's currently on probation for domestic strangulation, aggravated assault, false imprisonment, and criminal mischief. I want to highlight one of our sponsors, Upside. It's a free app that allows you to get cash back on daily essentials like gas and groceries. Every time I pump my gas, I now use the free Upside app because why wouldn't I want free cash back? Yeah, it's actually real cash back that appears in your Upside app that you can then transfer straight into your account. All you have to do is download Upside and then claim an offer on whatever you're buying. So you pay as usual using debit or credit and then follow the steps on the app to get paid. To find out how much you could earn, click the link in the description to download Upside or scan the QR code on the screen and use our promo code SIDEBAR to get an extra 25 cents back on every gallon on your first tank of gas. So this is a laundry list of charges, and there's some pretty major accusations here, and that's where we're turning to criminal defense attorney Michael Gottlieb. Thank you so much for coming on with us today.
Thanks for having me.
So reading through these injuries, just from the jump that this victim has, they sound pretty severe to me. I mean, we've got bruising, swelling. It sounds like maybe she even had a black eye to her right ankle, both her arms, her nose, both knees. I mean, what do you make of all of that? Does it sound pretty severe to you?
No, in fact, look, I'm a criminal defense lawyer, so to me, it doesn't sound severe. Those injuries are more consistent with a misdemeanor battery, not any kind of felony charge. Typically, for a felony charge, you're going to be looking for serious bodily injury or some kind of permanent disfigurement. So it doesn't really sound like it rises to that level.
So putting on the criminal defense attorney side of things, that's why we wanted to talk to you. And that kind of leads into my next question. So I'm sure investigators are looking for security camera footage or ring camera video, anything to kind of show that this happened. I haven't seen any reports of that. So let's say there isn't any. How would they prove who caused these injuries? I mean, is that a pretty strong defense that no one saw this potentially?
I mean, that's definitely a great defense. The first defense in pretty much any criminal case is not me. I'm not the one who did it. But I think depending on how the story goes, what I really saw as a potential defense here, if you're not going to go with it wasn't me, was the story from the alleged victim was similar as to both attackers. They hit me first, and then I was able to punch them back. I mean, typically, when somebody gets the jump on you, you wind up being defenseless, you wind up being guarded, you're covering yourself, you're not able to punch back. And the both stories as I read them sounded like she got the jump on me, I was able to punch her back. He took me to the side, he got the jump on me, I was able to punch him back. I think that similarity doesn't ring true. And typically, a male is going to be able to overpower a female. So it really sounds, especially a female who has just gotten into a fight, who is tired and injured, it just sounds implausible.
I think what's tricky about this too is it's kind of a he said, she said thing. It's kind of their word against each other. So she's saying this one thing happened, but the defendants may say something else. What do you think of that?
Right. And it's a he said, she said. So, if both defendants get together and have a joint defense agreement, in certain cases, there's strength in numbers.
Now, the charges here that they're facing are simple battery. Obviously, battery is not simple. It's very complex what goes into it and the aftermath, all of that. But just from the jump, that charge of simple battery, what does it really mean?
So simple battery is a distinction between a more serious battery, which would be a felony battery. So there's sometimes it's different states have different levels, whether they have a third degree or a second degree felony battery. A simple battery is a misdemeanor offense, punishable typically by 1 year, maximum 1 year in the county jail.
So this could have been more severe for them. They kind of got the lesser of the battery charges, it sounds like.
Absolutely. What would have made it more severe would have been a significant injury or if a weapon were used.
One of the interesting aspects of this case is that one of the suspects was arrested. She has since been released on bond. But the other suspect, the one who apparently had this relationship with the victim, he is now on the run. Does that make him a fugitive of the law if he has these charges against him and he's nowhere to be found?
Number one, yeah, it makes him a fugitive. But number two, if and when his case proceeds to trial or if he tries to get bond, the state is likely going to argue that his flight, his running, is conscious evidence of guilt. And so it makes him look guilty. He's facing a felony charges, much more serious than this, but also violent charges, also domestic violence charges. So he's in a heap of trouble compared to the other young lady that's been arrested. She'll have an opportunity if she chooses to testify against him as well.
Yeah, you're right. He does have prior convictions and was on probation at the time. And that kind of leads me into the next question. So we can talk about the search for him in a second, but let's say they have found him and this is going to go to trial. That kind of gets me thinking about prior bad acts because he kind of does have a history of that. I know that we can't always include those, but could the prosecution argue there's some sort of pattern because he does have convictions for domestic strangulation, aggravated assault, even false imprisonment?
Right. So typically, as you said, typically we don't include prior bad acts. There has to be some kind of relevance, some kind of similarity, some kind of modus operandi, something to suggest that what he did today is his character, as opposed to it's possible that somebody has two separate bad incidents, bad days, and they're not similar enough to be introduced. So you have to have a separate hearing to determine the relevance of that prior bad act conduct and then the admissibility.
Do you think that it is relevant in this case that he's accused of this simple battery that just recently happened, but all of these prior instances that happened before?
I think the relevance it would really need to be determined based on the facts of the prior case. If it was domestic, if it was a one-on-one, if it was planned, premeditated, one could argue that this one seems to have been planned or premeditated. You have to look at the similarities. If it's similar enough, since you want to, when you admit this kind of evidence, you're saying it's character evidence. So it has to be similar enough to say this is his character. Ultimately, I think it doesn't matter. He was arrested on a misdemeanor offense. If the state can prove that, they're going to get him on the violation of probation, where he's looking at much more significant time than a year in the county jail. So they don't even need to do that. It's a lower burden of proof on a violation of probation because it should be evidence that satisfies the court's conscience. To quantitate that, it's about 51%. Whereas in the new case, it's proof beyond a reasonable doubt, which is approximately 98%. So you could lose the new case, the misdemeanor battery, but I'm sorry, win the new case, strike that. You could win the new case, but lose the violation of probation.
I mean, at this point, all of this is irrelevant, at least for now, because we don't know where he is. He's on the run. What are you thinking? Is this something that investigators are going to work really hard to track him down based on the allegations against him that he could be a risk to this victim and maybe even the children?
Typically, people don't go back. It could happen. He could commit another act of violence against her, try to eliminate the witness from testifying against him. Typically, people they hide out with a girlfriend. Well, that's not really plausible here unless he has another person to add to the mix. Family or a hotel. I doubt, but it's possible. I doubt that he's going to go back to the scene of the crime and cause harm to his victim.
So, if there are locations that these people generally go to, a family member or hotel, things like what you said, why is it that we haven't found this guy yet? I mean, even in the age of technology, when we all have cell phones that can be traced or posting to social media, why is it that he's been able to kind of hide out for this long?
So if all they have is the misdemeanor offense and they haven't followed through yet with a warrant on the violation of probation, that could be part of the reason. Obviously, once he has a felony violation of probation warrant, it's a little more serious. It's going to amp up the manhunt, if you will, to find him. But beyond that, even though technology exists, you can't really track his cell phone. You have to get a warrant to do so. There are ways you can ping a phone and then get sort of a local area where he's at. We're not really there yet where we're able to track a person in real time without a warrant. And I don't know that there would be grounds to get a warrant in a case such as this.
Do you think it's possible then that investigators would reach out to the other defendant, his girlfriend, and say, hey, do you have any info? Has he reached out to you? What are his past patterns? Things like that?
I think it's plausible. I think they would or they should. But as a first time offender facing only a battery charge, she really doesn't have a lot of impetus to cooperate. It's not like she's facing a lot of jail time. If she loves him still and wants to protect him and she's in jail, she says, I don't know where he is. And, that seems to make a lot of sense. So I don't know that she really has any true motivation to cooperate.
But I'm feeling like prosecutors might, correct me if I'm wrong, go to her and say, hey, we can work out some sort of deal with you if you act as a witness in the case against him, if you kind of tell us what's going on. Because again, he has more serious things going on. The fact that he ran, he has all of this evidence against him in that way. Do you think that's something prosecutors would try to do to get a plea deal?
Yeah, I think they could if they're really interested in him and the victim says, "Look, I want him, to be punished for what he did to me. I'm not so concerned with her because you get victim input as well." Yeah, I think that that's very plausible. I just don't know that she has. Look, it's a misdemeanor offense. What is she facing here? At most, a year in the county jail, but a proper sentence would probably be no more than 30 days. So is it really worth it for her if she loves this guy, to become, if you would, a snitch against them? Or maybe she has a fear that he's going to come after her, if she tells on him. So I don't know that that juice is worth the squeeze for her.
Something that can't be forgotten in all this is the victim who allegedly sustained these pretty severe injuries, at least according to the report. And as we've discussed, as of now, we don't know that there's any security camera video or photos or things besides the victim placing these two defendants at the scene and causing these injuries. So then, if and when it does come time to trial, would she be the main witness? And if so, does that cause some issues that she's reliving this traumatic experience?
Well, yes, she's the main witness, absent any kind of electronic evidence. And there may be some texts, we're coming over, we're getting the kids, something like that, that places all three together. Once a crime has been committed, law enforcement can get a warrant for the cell phones of the two defendants. And by getting a warrant for the cell phone information, you could potentially see what towers they're pinging off. So at or near the time of the crime, if they're pinging off a tower that's within a specific proximity, they might be able to say, look, they were in the area, they were close, so her story makes sense. So there might be, absent the video, there might be other scientific evidence that buttresses her story. And then if she got beaten up by a random person, why would she pin it on these two? That doesn't necessarily make sense. One thing the prosecution never has to prove is motive. They just have to prove a crime was committed and who committed the crime. And they can potentially do that through this one witness, as long as she's credible and sympathetic, perhaps. She's the mother of children, okay, who was separated from their father. Their father's moved on to somebody else, and then the two of them ganged up on her. She's a sympathetic victim.
As you pointed out, the male defendant is connected to the victim in this case because they share children. Does that make things more complicated, putting this alleged crime aside, but at least for custody in the future? Could that make things a bit more sticky?
Certainly on his side of the fence, yeah. I mean, for the mom, it becomes a better issue in terms of who is the better parent to raise the children. If he winds up going to prison, obviously she gets custody of the children, assuming she's a fit parent. I haven't heard or seen anything to suggest she's not. She would have 100% custody when he gets out. He would probably be permitted some type of shared custody after reunification, after parenting classes, after anger management classes. That would take time.
It's definitely a difficult case to talk about on the domestic violence side of things. But Michael, thank you so much for joining us and breaking it down for us.
Sure thing. My pleasure. Thanks for having me on.
That's all for Sidebar. Thanks for joining us today. And make sure you subscribe to us on Spotify, Apple Podcasts, or wherever you listen. I'm Gillespie, and this has been Sidebar, presented by Law&Crime.